The government deflecting the blame for the spectrum pricing mess onto the NDA government, and the BJP-led opposition slamming the Congress. The blame game over the 2G mess rather has already begun. So far, the heat and dust obscuring any simple answers. We take a look at who is responsible for the spectrum mess.
The Supreme Court verdict in the 2G case has left the UPA shaken, with its key firefighters trying to deflect blame, saying it was only walking on the path already laid by the NDA. Amidst the heat and dust of allegations and counter-allegations, answers about who is responsible for the mess remain unclear.
First up, A. Raja, the DMK political and telecom minister, so far the only minister to have spent time behind bars in connection with the case. Raja is accused of giving due process of allocating spectrum the go-by during his tenure. Even senior officials in the telecom ministry cannot escape culpability, as investigations have revealed aberrations in the pricing policy. As head of the government, the Prime Minister is ultimately responsible for decisions of the ministers. The opposition also slamming Manmohan Singh, alleging he was aware of irregularities and did little to stem the rot. The Home Minister and ex-Finance Minister P. Chidambaram has not escaped the 2G taint, surfacing of a Finance Ministry internal note last year questioning the spectrum sale process with Chidambaram's signature on it, indicating his acquiescence has raised hard questions. The group of ministers responsible for pricing have also come in for censure. The GOM allowed the Telecom and Finance Ministries to take over the process of spectrum sale, with today's SC verdict questioning the first-come, first-served policy of the NDA itself. The BJP now having much to answer. It was during its tenure that at the center that the policy was initiated. The NDA government is also in the dock for allocating extra spectrum on subscriber-based criteria.
The timing of the judgment sure to trouble the UPA as it begins its campaign in important poll-bound states this year, with the opposition definitely getting a leg up in its campaign. Further, with a difficult budget looming, the government may find little elbow room for implementing hard but necessary reforms. Bureau Report, NewsX.
Well, the Supreme Court judgment today has also brought attention to bear upon the NDA years. This is how.
With the Supreme Court's landmark verdict today blaming the NDA regime first-come, first-served policy for the pernicious pricing in the sector, the BJP-led NDA has not escaped the 2G scam heat.
As you know, that was a policy that was decided upon by the then NDA government.
The Supreme Court's decision to basically roll back essentially the 2008 allocation of licenses while being cheered in many quarters raises the question of what happens to licenses that were given before 2008. The Supreme Court has essentially said that the first-come, first-served policy was wrong and that spectrum should have been sold at market prices. Now, when it applies this logic to 2008, increasingly voices are coming out that ask for that same logic also to be applied to all the sales and allocations of spectrum before 2008. If that is not done, there will not be a level playing field in the telecom sector, with companies who received their licenses and spectrum before 2008 enjoying substantial advantage over companies that get their licenses today, tomorrow, or whenever the government reissues its licenses. This was an issue raised by the CAG report as well, and perhaps now we'll see both the courts and the government attending to this point.
Now, while the opposition has lashed on this opportunity to indict the UPA-led government, with the heat turning up, the NDA may soon have to answer difficult questions. Bureau Report, NewsX.
Well, former Telecom Minister Arun Shourie now joins us to explain why perhaps the NDA years should also not be looked at, and if whether the government can actually deflect blame. Thanks indeed, Mr. Shourie, for speaking to NewsX. Why do you believe that this is the indictment of the Prime Minister and the Home Minister, as the BJP and other opposition parties are claiming?
Raja did not do these things on his own. Raja and Chidambaram, in consultation with each other and with the concurrence of Chidambaram, everything was done. Secondly, both of them kept the Prime Minister informed at every single stage. This is shown by the letters of Raja to the Prime Minister, by the Prime Minister's letter to Raja, and by Chidambaram's letter to the Prime Minister, and most important, by the note prepared by the Finance Ministry under Mr. Pranab Mukherjee. All that shows that they knew everything that was going on. So how is it just Raja's responsibility? That's the point.
No, except when Mr. Raja carried out the alleged fraud, Mr. Shourie, you know, the Supreme Court order, and I have this with me, recounts the series of events and seems to point to the fact that this was done, you know, in a clandestine manner, that neither the Secretary of Finance or obviously by extension the Finance Minister or the Prime Minister knew when the exact fiddle actually happened.
Well, you know, it is very surprising. Everybody in the world knew what was going on. All of you in the media were reporting it. It was front page news in economic newspapers at that time. Corporates were writing to the Prime Minister. Prime Minister himself said it. And now we go by this sort of sentence. In fact, Kapil Sibal has himself said, he has himself said, you look at your old footage in which he says that Raja kept the Prime Minister informed. And now to quote some sentence.
No, you know, in the judgment.
You see, if there were honest intentions, then these, after all, when the CAG report came out, it was on these very 122 licenses. You know, having followed this matter, how the CAG himself listed all the irregularities.
That might be so.
Should the government not have acted then? At that time they were saying, no, nothing wrong with it, nothing wrong with it. And now all that they are trying to do is to shield the Prime Minister and the Home Minister.
Okay.
And with this kind of a lawyer like Kapil Sibal, he's the only lawyer they can find to defend themselves.
No, Mr. Shourie, you know, let's just bring it back on the point. You know, in the judgment, and a copy of which I have, the TRA's, you know, FCFS 2003 policy, you know, has been declared discriminatory, and the government feels therefore that it shouldn't be held liable because it was only following a policy that was designed by the NDA.
My friend Rahul, this is there some religious scruple that they are following the policy that binds them to follow the policy of NDA? Secondly, is it only in telecom that they are bound to follow the policy? What kind of a defense is this? When the TRAI gave its reports, after that they did not follow the policies. You ask Mr. Nripen Mishra, the chairman of TRAI, what happened? And that is what the trial court is going into now.
Yes, but
so please, I can only plead with the Prime Minister and with Mr. Chidambaram, for both of whom I have great affection and regard. Please don't go by this nitpicking lawyers of this kind. The country does not consist of fools, my friend.
You know, Mr. Shourie, at some point the government has also said that to change course midstream would have bound the entire process in litigation. But to continue where you left off, Mr. Shourie, the FCFS policy is also applicable, you know, to the mining sector, one could say. By that logic, then, every government that has subscribed to this policy is equally culpable, guilty.
No, you see, please understand, please.
Yes.
No, I think that is a lot of nonsense, because it is the condition in this
that is a claim
that you have to see.
That is a claim by Mr. Sibal.
The question here was of following, of using the price discovered in 2001 to using it in 2007 when the tele-density has changed from 4.1 to 70%. And secondly, the more important point is that this Raja and the government followed no policy, no procedure. You tell me which is this NDA policy which they are following when retrospectively they changed the cut-off date from October 1 to September 25?
Yes, but that was Mr. Raja's wrong.
And thereby rule out 500 applicants?
Yes.
Or 300 applicants?
No,
which is the policy or procedure of NDA that they are following when they change the basis of first come, first served?
No, when they or
first
when Mr. Raja...
date and time of application filed. Then it was, no, date and time of conditions fulfilled. What are the conditions? Within 42 minutes, bring a banker's draft of 1,650
Yes,
crores.
but Mr. Shourie,
Which is the NDA policy they are following at that time.
no, okay, if the problem, Mr. Shourie, if the problem,
Similarly, after all this was done, the fellow changed the priority list so as to give Swan extra spectrum in Punjab and Maharashtra. This is good. What is NDA policy are they following in that?
No.
So this is a lot of, and the only, my friend, the only reason people like Kapil Sibal are able to spew this nonsense is that you people broadcast these things only because he's a minister today.
no, that might be
That
so.
is the only reason.
No, that might be so.
In no other country with a free press would this kind of a thing happen.
Okay, but if the problem is with the implementation of the policy, and you seem to allude, therefore, to the role, Mr. Raja in this singularly. Now, do you think the BJP's attack on the person of the Prime Minister and the Home Minister, therefore, is justified, Mr. Shourie, if you are by your own admission singling out Mr. Raja for fiddling?
My friend,
No.
where did you get this from that I am saying about the implementation of policy which is the doing of one person? Did I say that?
No, but you've just said,
I am saying the opposite.
Mr. Shourie,
But
you've just
Raja
said,
could not have done this. He is not doing this in a toilet with the door closed.
well, that
He is
hasn't
doing
been
it
borne
in the
out.
Open. All the media is reporting. The Prime Minister is receiving representations. The Prime Minister is writing a 2.5-page letter to Raja. And you say it is one person doing implementation? It is only to shield the Prime Minister, my friend, that they are trying to do all this. Prime Minister is asleep when
No,
ISRO
the
is
order-
happening.
Okay, the order,
He is
Mr.
not presenting
Shourie,
the scientists.
the
today.
order also, Mr. Shourie, says the
He
same
is
thing.
asleep for 1.5 years when the Ministry of Defence is making a botch of this. I have never seen such handling of an issue as
Okay.
of the age of the Chief of Army Staff.
No,
The most
that's a
honorable
separate
man.
issue. Okay, but that's a
And
separate
Prime
issue.
Minister doesn't know what's happening in newspapers.
No, let's bring this discussion back on course. If the court feels that the first come first serve policy of 2003 was at fault, was the genesis of this entire problem and caused loss, then the period of the NDA as well as UPA 1 should also be reviewed, Mr. Shourie.
Wasn't it the same experts propelled by the same corporate lobbyists who made this claim at 2 years ago, and that is why the CBI was put to examining all these things of the NDA period also. And as far as I am concerned, whenever they called me, I went there
Okay.
and I stuck to my position that I will come out and report to the media whatever they have asked me.
Yes.
And third, that when after all that they wanted answers to 14 questions, with my child in intensive care, I sat down the whole night and sent
Yes.
them the answers the next day. I don't need lawyers, I don't need any documents. And as far as I am concerned, they have told me repeatedly that they are completely satisfied with the answers we gave. So what is this, which is this expert that you are talking about? I would certainly like to get into his background.
Okay.
Last time you people were all the chaps, without reading it, you were quoting that Shivraj Patil's report, a fellow who could not have written that report in 1 month.
Well, that
And it
is
was
your
the
point
same
of view.
chaps, like Kapil Sibal, who got that kind of a report
No,
written.
we respect your point of view,
You
Mr.
would
Shourie.
not be able to fill a hall with the type of documents he would have had to examine if he had to write that report. But all of you, by reading one paragraph, Shivraj Patil
but
says
the-
this,
but
Shivraj
the
Patil
order is
says
out.
this.
But the
Now,
order is out.
plucking one sentence given to, recited by Kapil Sibal, you say, "Arey,
Not at all.
NDA ko bhi phir se examine kar lo."
No, not at all, not
Kya
at
baat
all.
ho rahi hai?
Not at all. In fact, in the
The
order,
case is going on in the case is going on in the trial court.
no, the court has made it
Supreme
clear.
Court has completely rightly
No, I
said
agree with you
it's
there, but the
trial
court has
is
made it
determining
clear
the course of this
that it hasn't
investigation
looked
and
into
course
the,
of
it
trial,
hasn't looked into the other
and
companies
let us wait and see what happens.
that were granted licenses, Mr. Shourie, between 2001 and 2007, because they are not parties to this case. But let's hope that this judgment, which many people are saying is perhaps limited in scope, will not stop the government from coming out and examining what happened prior to 2008-2007. On the back of that judgment, the opposition has gone for the jugular It has singled out the Prime Minister as well as the Home Minister for blame. The government on its part has put out a stout defense. Some have called it an attempt to pull a brave face and have said that the court has only questioned the policy, that it was a legatee too from the NDA years, as also the court has not questioned in any capacity the role of the present Home Minister and the then Finance Minister, Mr. P. Chidambaram, but has only indicted Mr. A. Raja, the then Telecom Minister. But at the end of the day, the question that needs to be asked is whether the government can deflect blame. Can in fact the government hide behind the line that it has taken all along, that it was merely implementing a policy that it was handed down to by the NDA? Let's open out those questions for debate this evening. Joining us, Mr. Mahesh Jethmalani, senior lawyer and member of the Bharatiya Janata Party. Also joining us, Mr. Vikas Singh, former Additional Solicitor General and someone who has appeared in different capacities in this case and has also been cited in this Supreme Court judgment. Rajan S. Matthew, the DG of the COAI. Also joining us, Yatish Rajawat, editor of the Dainik Bhaskar, Mr. Ravi Viseswarya Prasad, telecom expert, Mr. Vinod Sharma, political editor of the Hindustan Times, as also Dr. Subramanian Swamy, president of the Janata Party. Let me begin by asking you first, Dr. Swamy, a straightforward question. Why do you believe, as perhaps the opposition, BJP and the left do, that this order is an indictment, a severe indictment at that, of the Prime Minister and the Home Minister?
Well, I don't believe it's an indictment of the Prime Minister. It's an indictment of the Cabinet, and it's a collective responsibility, collective failure. As far as Chidambaram is concerned, originally I had gone to the Supreme Court to seek for a CBI inquiry. And I argued the matter, and then the orders were reserved, and it was taking a long time. And one wasn't sure with Mr. Ganguly retiring whether the order would be delivered or not. So I went to the trial court, and then with all the new documents that came on to my possession, and argued the matter, and the orders were reserved. Now, if the Supreme Court had agreed to my prayer, I would have been in trouble in the trial court, because then the whole reserving of that order would have become infructuous, and we would have to go back to the ab initio. So the court in its entire order has recorded what I said. They have rejected what Mr. Chidambaram's court lawyer, Mr. P.P. Rao, said, and then said that however we will not decide, because Mr. Swamy is already well into the trial court proceedings, and therefore we empower the trial court to decide this matter of whether a CBI inquiry is necessary or not. Now, I personally believe that now the CBI inquiry is not necessary for summoning Chidambaram, but subsequently in the conviction I would like the CBI to assist me. Earlier on, the trial court could not call for a CBI inquiry, because the Supreme Court had decided that only High Courts and Supreme Court can decide on who, when CBI will investigate and when CBI will not investigate. So here there has been a special dispensation made by the Supreme Court to empowering the trial court to decide. So it's much beyond what I wanted. And I was very happy, and this is obviously, if this Mr. Chidambaram was not, was in fact to be excused or Mr. exonerated, they would have said, yes, Mr. Swamy's case doesn't have any basis at all.
No, that is with regards to that is with regards to your plea about the Home Minister. But you know, it's interesting, and I'm going to go across to Mr. Jethmalani after you answer this question. It is interesting, Dr. Swamy, that you differ in a nuanced manner with the opposition parties like the Bharatiya Janata Party that have singled out the Prime Minister for blame.
Yes, I do. I don't think Prime Minister alone can be held responsible. It's a collective responsibility. I know that Raja had a patron above Mr. Manmohan Singh, and therefore there is no place where Mr. Manmohan Singh was authorized or was empowered or was specifically said by some cabinet decision that he has to decide, and he decided in a malified manner. Here, Mr. Chidambaram and Mr. Raja were empowered by the NDA government general decision that Finance Minister and Telecom Minister must decide. And these two have decided.
Okay, so
I see that Prime Minister can be guilty of malfeasance in office, but he cannot be held for having committed any criminality.
Okay, I'm coming to you, Mr.
Therefore, I would
Rajawat.
like the whole cabinet to be held responsible, not Mr. Manmohan Singh alone.
Okay, fine. That's an interesting distinction you make. I'll come to you, Mr. Rajawat. Let me bring in Mr. Jethmalani. Mr. Jethmalani, would you like to reply to what Dr. Subramanian Swamy has said? Because he's making a distinction that the BJP is failing to make.
Look, Rahul, I don't think the BJP is saying something very divergent from what Subramanian Swamy is saying. The BJP has not said that the Prime Minister is criminally responsible. What the BJP has said is that the Prime Minister, as the head of the cabinet, is responsible for a massive policy failure. Once the Supreme Court has cancelled the 122 licenses, the necessary implication of that is that the policy was illegal.
No, it's interesting.
The allocation was illegal. No. What Dr. One minute, Rahul. What Dr. Swamy is saying is that the entire cabinet is responsible for that illegal policy which resulted in the allocation of the licenses and the spectrum with it. What the BJP is emphasizing is
the allocation was illegal.
Can I just interject?
The allocation was illegal, and the court has come out very clearly. In fact, I'm holding the judgment in my hand.
Now, if you see the judgment, it says very clearly that there are two flaws.
Yes.
One is in the policy, and second is in the implementation of the policy.
That's right.
Which is why it is.
Sorry, I didn't get that.
It does not
let me 1 minute, Mr. Rajawat. 1 minute. Let me complete my question to Mr. Jethmalani. Mr. Jethmalani, I'm sorry that you got interrupted there. I'll come to you, Mr. Rawat, but this is a fine line, and one has to, sort of tread that line. Mr. Jethmalani,
you're absolutely right that there's a distinction between the policy aspect and the allocation of spectrum. On the allocation of spectrum, there is no doubt that the court has held it to be illegal. The policy, the policy they say was a continuation of the NDA policy, and that was based on tele-density. The only question that
if it's a question of loss, then surely the NDA's tenure must also be examined, shouldn't it be?
No. The question, I'm sorry, I disagree with you. Because what may have been a policy in the light of the then prevailing need for tele-density was not a prevalent factor in 2008 and 2009. I'm completely sorry about that. That's a fallacious and a very contrived and convenient misuse of a previous existing policy.
But the court has found the then minister.
Now let me finish, then you can contradict me.
Yeah.
The tele-density argument that may have been valid for the formulation of the 2003 policy had no basis in 2008.
Okay. Mr. Rajawat, you wanted to come in there.
I just wanted to make 2 points here. One, if you read the judgment, it says very clearly that the policy of first come and first serve involves an element of pure chance or accident, and I'm quoting the judgment here.
Yeah.
And especially in matters of award of contracts or grants of license, the implication of first come first serve policy has inherently dangerous implication.
Yes.
What the Honorable Court is saying that this policy was flawed, and it is also making a comment on its implementation. If you go back to the section 75 of the judgment, it says very clearly that the Minister of Communication and Technology at that time misused it.
Yes.
To say, I'll quote again, to say the least, the entire approach adopted by the TRI was lopsided and contrary to the decision by the Council of Ministers.
Yes.
And its recommendations became a handle for the then Minister of Communication and IT and the officers of DOT, who virtually gave it away the important national asset.
Yes.
If you notice, and we can get into the this thing of it. And
no, so your central point, correct me if I'm wrong, Mr. Rajawat, your central point therefore is this. That when the opposition tries to spread the taint, it is being selective in its indignation. Is that what you're trying to say?
I'm trying to say that the court is very clear that who misused the policy, and the court is very clear that what was wrong in the policy.
Mr. Sharma,
we are reading too much into it without reading the distinction.
That it seems today is being muddled. It's being muddled perhaps with a definite political end, and on the face of it, who can deny the BJP its finest hour? Mr. Sharma.
The question is not deniable. The question is that we should stick
BJP
to
is going to
facts.
exploit it politically. They are the opposition. They are the principal opposition, and they have got an issue on a platter. Though they didn't work at all for it, it's all the hard work of Dr. Swamy, who is not a member of the BJP, incidentally. But may I say that this judgment, my reading of this judgment, in which I have over the past 2-3 hours, I have read this judgment very closely. My reading of this judgment is very different from that of the BJP. I feel this is a judgment against A. Raja specifically, and in that limited sense, it vindicates the request that Dr. Swamy made to the Prime Minister for sanction of his prosecution.
Yeah.
This vindicates him on two fronts. One, that he made the right application, and secondly, that the Supreme Court has upheld all the issues that he raised against A. Raja. Insofar as not taking up licenses between 2001 and 2007 is concerned, the court very clearly said that these cases, the people who got those licenses are not parties in this case.
That's right.
And the legality of those allocations has not been questioned. Now, I believe that when some of the affected parties
You're
will
putting
go
clause
for a
71.
review
You're
to the
putting
court.
clause 71 of the judgment.
When some of the affected parties might go in for a review before the Supreme Court, and then these issues may come up, that 2001 onwards, and then we'll know whether the Supreme Court really felt that this policy was right or not. In this case, the Supreme Court has questioned the implementation of the policy, has questioned the honesty with which the nodal ministry, which is the telecom ministry, implemented this policy. They have gone into great detail as to how the telecom commission's meeting was, was rigged by the minister.
Why then is the BJP, is the BJP expanding the scope of its attack when it knows willfully that by doing so would not be actually adhering to the very letter of this order?
But let me tell you one thing, unlike Mr. Sharma, I don't know what the fulcrum of the order is, because I have not read the entire judgment. I'm in the process of, even as I speak to you, I am now looking at it.
Yes.
But let me say this, that one of the crucial charges, let's get away from the judgment for a minute, and I don't know what the judgment says on that, and perhaps Mr. Sharma and you have both read the judgment, can enlighten us on this. One of the crucial charges, and I think that's Dr. Swamy's allegation as well, which is coming up on the 4th, is the misuse of spectrum allocation. It's undeniable that even under the NDA policy, the telecom policy of the NDA, one thing was clear, and I think that's highlighted by the Supreme Court as well, that the allocation of spectrum was to be open and transparent, right? Now, one of the charges in the trial court is that the allocation of spectrum in this case was not. And if the Supreme Court has reiterated that it should have been, Raja is inter alia charged, as you know. One of the charges against Raja in the trial court is that he was responsible for misuse of spectrum allocation. Now, if the evidence which Dr. Swamy has brought before the trial court suggests, and I think he's got a very strong ground then, but I don't want, since the matter is sub judice, I don't want to prejudice Mr. Chidambaram.
Well, your party seems to be already prejudging this issue. Perhaps it should learn a few finer points of the law from you, Mr. Jethmalani.
No, Rahul, look, that's a little unfair. Political parties, let me tell you why you're being a little unfair.
Maheshji, even Dr. Swamy has till now not demanded the resignation of Mr. Chidambaram.
No, nobody.
He is waiting for the lower court, for the trial court to take a position. While your party has gone to town, I'm not objecting to it. Politically, you are very right.
Absolutely.
We are on the legal
no one
issue.
Can deny the
politically, nobody questioning your right to demand his resignation.
Absolutely.
This is election time. You really want to exploit this issue. No quarrels with that. But insofar as the legal issue is concerned, the matter today is before the trial court, the special judge of the CBI, where Mr. Swamy's petition plea is pending to make him a co-accused. We shall know on the 4th. What was the great hurry for the BJP to demand his resignation now?
Let Mr. Jethmalani respond before I open out the panel further.
Can I just quote a section of this thing to just...
I'm coming to you, Mr. Rajawat, I'm coming to you. Yes.
Look, either you're mainly a politician or you're a lawyer politician. A lawyer politician will nuance it by saying, look, I'll wait if there's a prima facie criminal case against Mr. Chidambaram. But political parties are entitled to say that, look, Mr. Chidambaram has a moral responsibility.
Absolutely.
And in the highest traditions of a democracy, once 1,76,000 crore loss has been called and the entire allocation has been scrapped unceremoniously by the Supreme Court. The person, after all, he was the finance minister on spectrum allocation.
Absolutely. This is a definite indictment. This is a definite indictment, Mr. Jethmalani. You are absolutely right on the process and the procedures within government. No doubt about that. And therefore, let me quickly expand the scope of this debate. Let me bring in Mr. Vikas Singh, former Additional Solicitor General. Mr. Vikas Singh, at best, at least on the basis of what we've seen today, at best one could make out a case against Mr. Chidambaram for the sin of omission. May not be for commission, but certainly for the sin of omission.
I'll tell you, Rahul, as far as Mr. Chidambaram is concerned, I mean, the policy decision of having the spectrum at a particular price, I don't see how he can, save himself from that decision, unless if the government had taken a call to defend the entire decision itself. I mean, this is a case where, if I remember correctly, I was present in court. The Attorney General didn't even argue the case on behalf of Union of India because he said that the matter is pending before the JPC, the CBI and the PSC, so the government would not like to take a stand. And the main person who argued on behalf of the private licensors who had been given these beneficiaries, Mr. Salman, he also didn't really, he also virtually agreed with the court that the entire licenses that have been given are wrong and that they should all be cancelled and that the cancellation should take place from 2001 because that is what...
in fact, let me bring in Mr.
He only said that extra spectrum, in fact...
Yes, okay. Yes, go ahead, Mr. Vikas Singh. I'm sorry to have interrupted you there.
Yeah. If you see the judgment, the learned judges actually don't will the 2001 to 2007 period because they say that is not the case before them.
That's right.
I don't know why it is not before them. Actually, the petitioner should have made that case also before them. It's a little surprising. And all those parties who were beneficiaries of that period were also not before them. So the judges were very right in saying that since they are not before us, we can't decide.
Swamy that question. Let me in fact ask Dr. Swamy that question. Dr. Swamy, what holds true in the present also holds true for the past, doesn't it? You know, if the policy is discriminatory, as the Supreme Court judgment says, why shouldn't the NDA also be equally liable? After all, if this policy at the very beginning caused loss to the exchequer, then what holds true for 2007, 2008 would also hold true for 2003. Albeit the circumstances, the economic circumstances might have been slightly different. The nature of the evaluation might be certainly different. But definitely, the same would hold true for the past.
No, what is the license has been cancelled? Why? Because it was a malified exercise of power.
Yes.
And whether the TRI recommendations were violated or not, of course there are many violations.
I'm asking you to respond. No, I'm asking you to respond. You know, we are not getting into the merits right now. I'm asking you to respond to the question that is being posed by Mr. Vikas Singh.
Listen, first of all, the loss of revenue was due to the fixing of the price in 2008 at the 2001 thing. Those who who didn't deserve to get the license got it because of that selective first come first served policy. Now, as far as NDA is concerned, I'm not stopping the government from prosecuting the NDA. After all, I'm only going after the government of India because the government of India will not prosecute itself. So therefore, as a citizen, I am going after the government of India. But if the government of India says that the NDA is also responsible, who's stopping you from prosecuting them?
Mr. Vinod Sharma,
they are the ones, they've got the CBI,
why isn't the government of India prosecuting?
They've got the NIA, they've got everything. And I am a private citizen, so I cannot be expected to also go after the NDA. The NDA, if it's guilty, let the government prosecute them.
Dr. Swamy has a point there, but the main issue here is that if you reopen the 2001 cases onwards, you see there has been some discriminatory allocation of spectrum to existing players.
That's right.
If Mr. A. Raja had stuck to the policy and had stuck to his argument that he wants the 2001 prices to afford a level play field to the new entrants, to new operators, when in competition with the old operators. But what he did, where he went wrong and has got caught is that he allocated licenses, gave licenses to players who had no experience in the telecom business, A, and B, he manipulated these allocation of licenses by cutting out certain genuine aspirants who should have been given a chance, but he didn't. He picked and chose his cronies.
That was the alleged fiddle.
I mean, it is a typical case of crony capitalism. It is a typical case of crony capitalism where Mr. A. Raja wanted to support certain companies, which he did. Had he stuck to the policy, had he stuck to the argument level play field, maybe he wouldn't have met the fate that he has.
Mr. Rajawat, isn't that the point? Isn't that the point that the alleged fiddle took place on account of Mr. Raja?
See, I agree with you, Rahul, there. There are two issues that Mr. Sharma pointed out. One is that between 2001 and 2003, there was spectrum allocated. The policy itself was not followed. There has been hoarding of spectrum which has taken place, and it has taken place by the incumbent. The first come first serve policy, which was opened up by Raja,
yes,
actually was implemented in a wrong manner. It was implemented in a different manner by the other governments.
But Mr. Vikas Singh has made an important point. He says that the one point on which Mr. Chidambaram perhaps cannot defend himself is on continuing with the policy when it had become apparent that it was going to cause a loss of the exchequer. But even to that, there is a counter.
Was not implementing the policy.
Yes, I understand that. And that's the point that I wanted to make. But let me bring in Mr. Prasad. Mr. Prasad, there was another greater concern. The concern was that if mid-course you were to go in for a correction, there would have been litigation. As the prospect stands today.
Yes, certainly. In fact, today the court did something very unusual and commented on policy which normally courts do not. In fact, courts have typically held that policy matters are outside the purview of courts. But today the court actually criticized the first come first served policy which had been formulated by the NDA government. And if I remember right, in the 1990s there was a case of Doordarshan of allocation of slots on Doordarshan satellites.
That's right. That judgment is quoted.
Which was there in the early 1990s. Yes. Where the Delhi High Court had held that first come first serve was illegal and arbitrary, and it set aside that particular tender of Doordarshan. Now.
But the Madras High Court came out
with
the
Madras High Court came out with the contrary one and said first come first serve is all right because it doesn't discriminate against.
Yes, it is interesting, Mr. Vikas Singh. Let me just draw your attention to page 83, clause 72. Clause 72 of this judgment, before I go across to Mr. Jethmalani, says that that ordinarily when matters like these are brought before the judicial constituent of the state by public spirited citizens, it becomes the duty of the court to exercise its power in larger public interest and ensure that the institutional integrity is not compromised by those in whom the people have reposed trust and who have taken oath to discharge duties in accordance with the constitution and the law without fear or favor. And it is on this basis that the court has come out and commented in quite a broad manner on what is really a policy matter. So from that point of view, Rahul, the benefit of hindsight is always 20/20, and once all the facts are known and of course everything comes clear and out, it is easy to pronounce judgment. But at that point, Mr. Chidambaram may not have known. If one were to give him the benefit of doubt, may not have known as to how this would have unfolded.
The interesting thing, Rahul, here is to agree with you, Rahul, on this.
No, I don't agree with you on this. If you see how the sector has performed over the years, I mean, everybody knew that even if you give additional spectrum to anybody or you give a new license to somebody, the value of the license definitely has changed over a period of time because of the business module, because of the growth in the sector. So to say that I will peg the prices at 2001 without knowing that the prices would have gone up in the meantime. I mean, everybody knows how the sector has performed. You have seen, there was a time when Bharti Airtel was about to go bankrupt, and today Bharti Airtel is among the Fortune 500 companies in the world.
Okay, so let me bring in the perspective.
To say that Mr. Chidambaram would not understand.
Yeah. Okay, let me bring in Mr. Rajan Matthew, who's the Director General of the COAI. Mr. Matthew, wasn't there the possibility of litigation, which was something that the government was conscious of? It is well documented.
Yes, Rahul, there very clearly was an issue of litigation, and there was litigation all along. But the principal factor that is of importance to focus on, in our opinion, is the fact that we've been saying all along that spectrum is the mother's milk of this industry. And this has been at the root cause of much of what has been litigated and debated and now contested. And so the fact that the court has come back and said all along what we've been saying, that this must be done transparently through a market-based mechanism, preferably an auction, that is the way to go, is something that we support wholeheartedly. And I believe that if that had been followed, we would have escaped a lot of what we are going through right now.
Okay, let me bring in, we are winding down this discussion, but let me bring in Mr. Jethmalani. Mr. Jethmalani, it is quite instructive, if you're there with us, it's quite instructive that Dr. Subramanian Swamy has felt that there is a case that can be made out against the NDA too in this particular issue.
Well, I think you're putting words in his mouth. He says, if there is a case, I'm not stopping anybody from doing it. He doesn't say there's necessarily a case. And by the way, I can only say this, that the CBI has called Mr. Arun Shourie, who was the telecom minister. It has interrogated him extensively on a number of days. And I saw Mr. Arun Shourie appear on a particular channel this morning to say that the CBI, after extensive and intensive interrogation, had actually given a clean check to the NDA. Now, I'm not saying that's true, but I certainly heard Mr. Arun Shourie on the channel say that today. So the matter has been gone through threadbare by the CBI, and they have failed to come through. It's undeniable that Shourie was called.
Okay. Rahul, let me draw in Dr. Swamy.
Rahul,
last question to you, Dr. Swamy, before we close down the debate. The judgment, in the judgment, the TRI's first come, first serve policy has been questioned. It has been declared discriminatory, and the government feels, therefore, that it shouldn't be singled out, and that it was merely following in the order of what the NDA left behind as a legacy.
No, what is the license has been cancelled? Why? Because it was a malified exercise of power.
Yes.
And whether the TRI recommendations were violated or not, of course there are many violated. For instance, the TRI said there should be no cap at all. Mr. Raja introduced a cap by introducing a cut-off date of October 1. So there are many TRI recommendations which were violated. The TRI also said you can, yes, fix the entry fee at 2001, but then the bundled spectrum should be auctioned. But both Mr. Chidambaram and Raja together decided that the bundled spectrum will be given free of charge, zero cost, zero price. That was what is very surprising. So they have selectively, as Mr. TRI chairman wrote later on 14th January 2008 to the Mr. Behura, that you have selectively applied the TRI recommendations and then said that we are following the TRI recommendation. This is not correct. Either you have to look at the whole thing or nothing.
Okay,
and yes.
Mr. Sharma, final thoughts from you. Where is this story headed now?
Well, this story is headed to the Supreme Court special judge of CBI, and we'll get to know on the 4th whether Dr. Swamy's plea against Chidambaram finds favor with that court or not. But I may point out that in its judgment today, the court has given details of what all transpired between various institutions responsible for implementation of the policy, without making a comment or passing a stricture on the law ministry, on the then finance ministry, but its focus has been entirely on A. Raja.
Okay, so
that is where that's what makes me more interested in what will happen in the trial court.
Right. Okay. Thanks indeed, gentlemen, for joining us this evening and presenting your point of view. Let's wait for the verdict on Saturday.